so many terminologies: cyber warfare, cyber operations, cyber security, communications, information, all that kind of stuff. But what we are really about is warfare or operations that take place in the domain of cyber. So something has to do with internet, software, computers, as I will explain. So we will move forward with that in mind. Some of the questions that, of course, you've probably realized that IHL is a huge domain. So by now, every one of us understands that we can write books and volumes about so many topics, and that's also the same case when it comes to cyber warfare. So we could make, a full series of lectures and books about cyber warfare, about how does IHL apply, whether it applies, all these questions. But essentially, I think some questions seem to linger more than others and are more made aware to others, to most of us as experts or as students of IHL than other questions. So one question is, does IHL apply to cyber attacks? That's still a relevant question today because there are no treaty law. What constitutes an attack under IHL? Perhaps one of the questions that is posed by your case. When does international humanitarian law apply to the use of information and communication technologies? Does the destruction of data constitute an attack? So not using cyber attack, but actually attacking cyber, whether this is also covered by IHL. So another question would be, what would be the consequences if IHL is deemed inapplicable to cyberspace? And this is more of a theoretical question. So today we'll tackle some of these practical questions like we did last time. So last time was purely practical, something that would otherwise be useful to you in moot courts or at your work if you do apply IHL in real life. But this time I'm gonna delve into more theoretical aspects so that we don't spend so much time on the questions that might pop up already in your case, moot case. So in the background, you'll see a figure, and that figure actually represents how cyber attacks or cyber operations increased in the last years incrementally. If you look at the year 2021, 2022, 2023, you'll realize that, oh my God, like this huge spark of cyber operations. And I will share some of these with you today, but have that in mind that cyber operations specifically recently have been increased, and that makes them both relevant and interesting for researchers to delve more into, but also for states to try to regulate these kind of attacks. So what we also call or refer to by cyber operations is the same as information and communication technologies, capabilities for military purposes. So because when we use cyber operations, we might be limiting the spectrum of the things that could be used. So we could have an ICT that could be used for a civilian purpose, but also for a military purpose. But the fact that it is used for a military purpose, it makes it go into that domain of cyber warfare. I just wanted to highlight that. And if you look at the work of the ICRC, the work of the experts literature, you will find that everyone is pointing to the significant increase of these operations, both by states or governments, as well as by non-state armed groups. We also will hear from so many experts, and as well as in United Nations forums, that international law basically doesn't regulate cyber operations. So it's a bit of a puzzle. Does actually the law regulate cyber operations or not? It's still a bit of a question. And then I invite you to look at the work of the group of governmental experts on development in the field of information and telecommunications. You will find that they are trying so hard to pinpoint the position of states, really, how international law in general applies to cyberspace, specifically how IHL apply to cyberspace. And of course, we'll find the ICRC voicing a lot of concern about the implementation of existing rules. Okay, so the position of the ICRC then would be that if we don't have treaty law specifically regulating cyberspace, then we can use the existing legal norms. And we will, across this presentation, we'll see how this is being done or being argued, and the opposite side as well. And ultimately, what I would like to bring your attention to is the calls for further discussions. And that means that this is a final confirmation that there is no regulation. And although there is a consensus that existing rules actually apply, still we need a treaty that specifically say which acts of cyber operations qualify as prohibited or not prohibited, and how and to what extent. So all these are questions. You can go to all these reports and look at them and look at the arguments both in support and against, which might be relevant to your moot case as well. So why do they actually voice these concerns? Ultimately, because of this last sentence, devastating humanitarian consequences. So there is an assumption now that cyber attacks can cause devastating humanitarian consequences. As you also saw in the moot case, there is a potential that one cyber attack on one specific building that can cause so many multiplied impacts that also impact the civilians and civilian objects. So this is actually an image that I found online, and I thought to share with you. It actually, I didn't really find this distinction in literature, but for the sake of understanding what we're dealing with, cyber attacks could actually relate to two types of cyber attacks. One that is a cyber attack per se, so a malware or a virus or hacking kind of operation against a facility or specific individuals or entities. And another that would be a physical attack against a computer or the internet or etc. So could actually be either ways. So while I was looking into more of the existing literature before this presentation, I also realized that not so many people talk about the actual situations on ground. Like, what do we really mean by cyber operations that take place? So I thought to share some insights on two cases, one about the Israeli-Hamas war and one about the Russian invasion of Ukraine, and bring some statements and some of the events that took place already in real life, and just to gain some insight on how these operations can take place. So it's made known, especially in Europe, because it's one of the more relevant conflicts nowadays here in Europe, is the one that relates to Russia's invasion of Ukraine, both in 2022 and before, when Russia occupied Crimea. So we hear about this mobile network of Ukraine, which is called Kyivstar, and it was hit by cyber attack on the 12th of December last year. The attack disrupted air raid sirens, so basically people who usually get notifications about raids coming from Russia, these alarms have stopped essentially, and the texts that the citizens would get, they would also not be able to get them because of this hacking operation. Then we have the UK's Ministry of Defense pointing out that this is one of the highest impact disruptive cyber attacks on Ukrainian networks. And then we hear about a group that is called Solentis Pyok. I don't know how it's pronounced in Russian or Ukraine for that matter, but that group actually claimed that they are responsible for the attack. So here also we hear about hackers going, out and saying, okay, we did this attack and we did it for that reason and that reason. In some other instances, of course, we don't know who committed the attack, because it's insanely difficult to trace these attacks in the cyber domain. Of course, Ukraine would claim that this cyber operation is linked to the government, so that they would trigger more international rules to fight Russia back, legally speaking. And then we see that Moscow did not comment on this, and we also see that there is some criminal investigation into the matter in Ukraine, but also we see that Ukraine also started to collaborate with the ICC, sending evidence, etc., and then making big statements on media that these attacks basically hurt the Ukrainians and Ukrainian civilians. If we look at the last couple sentences, the cyber attacks were directed at digital infrastructure such as power grids, if it rings a bell to you, data services, and critical infrastructures. So you might want to look at these incidents, specifically this one, because this one for me is well documented. So I thought to bring it to your attention. And it also might be one of the incidents and the discourse on this incident, what might be relevant to your case as well. But I'm not going to delve deeper than that. Okay, another conflict that is both interesting to us as people who follow the Palestinian struggle since we were born, and also as lawyers who apply international law, in particular ICRC. This conflict is one of the conflicts that we keep an eye on, and we try to see the developments both in real life and from a legal perspective. Quite surprisingly, though, that it's something that not so many media outlets talk about, but there is a huge cyber warfare going on in that domain. You would see these cyber operations by the occupying power or the Zionist state of Israel, but also by Hamas and pro-Palestinians at large. So in so many ways, there is operations going on against the Israelis, but also against Gaza and against Hamas in particular. So for the ones that are launched by Hamas and the pro-Palestinians, I got this first type, which I wasn't exactly familiar with, but over time I got to understand how it really functions, which is called DDoS, Disrupted Denial of Service. And these operations basically consist of flooding the internet. So we basically have a website as a target, and we say that this website would be the target or the objective of our operation. And we, as hackers, we would then flood this website by fake requests. We just make fake requests, millions of requests, either from our computers or computers that we command, or bots, or via innocent computers that we hack and then direct at that website. The idea, of course, is to bring that website, however significant it is, to bring it down. One incident in particular was bringing down the website of the renowned Jerusalem Post website, which belongs to the Israeli government. You could read on it a little bit more on the Cloudflare report. Okay, and also here we have two groups that actually said or claimed responsibility for this attack. One is Team Insane Pakistan, and the name tells where those people might be coming from or where they're located, and also Anonymous Sudan. It's also another group that is seen as affiliated to Hamas. Okay, moving on. We also have Viper malware, which is basically a more sophisticated approach. It's designed to raise data from files by overwhelming or renaming them, or by creating random strings of data. So basically, it's like a virus. The easier way to look at it, one that tries to create data or eliminate data or remove it. And you might know a little bit more about these aspects since you're interested in information technology in the first place. So we have one incident that was quite known. Maybe you can look at it, which was an operation called BB, and BB refers to Benjamin Netanyahu. We know who that person is. He's now wanted by the ICC, and these attacks were not claimed by anyone, but they were attributed to other groups I mentioned them here: Gaza Cyber Gang and Arid Viper. They created these operations, but the Israelis could block them. I see that you could also look at this other one, the Ona Academic College. That was another attack that was actually operated against a college, a private college in Israel, and it's basically consisted of hacking and leaking the private information of the students, which would make them vulnerable to attacks by other people in whatever form. Also, the Israeli rocket alarm application, Red Alert, and that still is in application that the Israeli government uses to notify people of incoming attacks, and that was also hacked by a group of hacktivists and called Anon Ghost, and basically they used it to send fake notifications to terrify the people, basically saying that nuclear weapons are coming at you. They used it in several ways just to disrupt the application. We have more, but I think the most interesting one is that cyber attacks in that particular war in Palestine increased by 52% since the 7th of October, and that's already telling about it. Of course, I can go on and on about Israel's intelligence and cyber operations, which did not only commence from the start of the 7th of October, but it was made clear that with a click of a button that they could stop the internet, that they could stop electricity, that they could do more and more. So we have two incidents that have been particularly recorded since the start of the war between Hamas and Israel on the 7th of October 2023, and that was the one on the 27th of October, which was an internet blackout that lasted for 34 hours in a row. And also the fact that the connectivity in Gaza up until this moment is extremely declined. So basically, you could log in and log out in minutes, not seconds, like we are used to. Okay, let's get to the technical part, which might be interesting to some of us, but less interesting from a storytelling point of view. The first question, unfortunately, from the cyber attacks. So I'm now zooming out a little bit on international in general, because up until today, nobody is 100% sure whether international law applies whatsoever to cyber attacks. Some people say it operates in a vacuum. We don't know. There are no specific regulations up until this moment, like it is the case with other weapons or other means and methods, of warfare. So we start by the question of, or the fact that cyber space is not a legal vacuum. So it has to be ruled. It's not outside of this reality. So we have to rule it. And this is the position of so many experts, that international law is extended to that space as well, as much as it is extended to anything else. Cyberspace could be said, or most definitions that would define that terminology would say that it has two dimensions. One that is physical, and that would include computers, like I'm trying to show here in the second picture: computers, wires, data, equipment, infrastructures, buildings that would host these equipments, but also a cognitive or operational or functional dimension, which would be the software, the data, the process of exchanging data, and etc. So you would generally see the position, or everybody would come generally to convince you that international law applies to both dimensions. And the main argument here would be, why not? So that's the perspective that we will linger on for a little bit. Why not IHL or IL apply to cybersecurity? And the assumption here is that since cybersecurity or cyberspace or cyber operations are not specifically mentioned, then the law is unsettled about it. So if we apply that rationale, we will see that international law applies to both. And it seems like a consensus to me also online on the position of the experts and judges worldwide would be, it's no question that international law applies. It's a question of how it applies, actually. Yet there is this, the point that I'm mentioning in number 5, that lingering uncertainty about cyberspace, that there is no direct international law or treaty. So others could certainly argue that, well, we don't have treaties. States meet every year, meet every month. They have many platforms, as you see, but up until this moment, they did not agree on the way forward. Therefore, up until now, cyberspace is not regulated. So that's an argument that could be made. Anything could be made in the realm of law, and specifically international law. Okay. Now we go to how, that's basically an example from international law. So probably I'm not quite familiar with your level of knowledge about cyberspace. Maybe I should have asked Abdurrahman earlier about that, but I would assume that this example would be beneficial to most of us. And I bring it from the Vienna Convention on Diplomatic Relations just to show you how existing international law could apply to cyberspace. And then I will move to do the same process also in the field of IHL, just to get the idea of the methodology of argumentation in that kind of field. So look at it as a methodological kind of process. So I will get an example from the Vienna Convention. I will, for example, shed light on Article 22, Paragraph 1, which said the premises of the mission shall be inviolable. The agents of the receiving state may not enter them except with the consent of the head of the mission. So here we are talking about premises, which doesn't really have to do with cyberspace whatsoever. So if nobody would really bring this rule in particular and say that it relates to cyberspace, it doesn't really relate to cyberspace by virtue of mentioning something that is concretely specific, which in this example be the premises, a building basically. We take another example, which would be Article 27. It states the receiving state shall permit and protect free communications on the part of the mission for all official purposes. And then we see that also Article 24 says the archives and documents of the mission shall be inviolable at any time and wherever they may be. So there are two ways to look at archives and documents here. One, to look at it as only actual physical documents, but also another way to look at it and see that this one includes any types of documents. So this is really how it goes, that you would look at normal rules and whether they could be somehow extended to the digital reality. And of course, the other side of the argument would keep with the classical approach, say the text was written down before the age of cyberspace, before internet. So how come you're applying this rule here? So the process or the methodology would be to examine the specific content of individual rules to determine whether they are relevant to cyberspace, and if so, how they apply. Okay. Back to IHL. So we asked the first question, does IHL apply to cyber operations? To cut to the chase, I say yes. Of course, there are other arguments that would somehow argue no, but not so many people or not so many experts would argue that, because it sounds really evil. So because IHL really protects civilians and civilian objects. So if you argue that it doesn't apply at any rate, then you might be arguing on the wrong here. So to cut it short, it applies to cyber operations. There is some consensus on it, yet there is no IHL treaty that regulates cyberspace. Same as public international law, many principles and rules are technology neutral. So you can extend some of the rules, but this is a process that you will be doing. So based on the case facts before you, you can actually, I see Kenzie here asking a question. Go ahead, Kenzie.
Yes, just the last slide, you example of the Vienna Convention.
Yeah,
I read the Vienna Convention, and how is it related to the cyberspace?
exactly that's point. Thank you for your question. So the exact point here is that cyberspace is not regulated. So this is the first fact. The second fact is, what do we do now? Do we say that international law does not apply to cyberspace? So one side would say it doesn't apply because there's no treaty, and the other side would simply say, okay, let's look at every text and deduce what the text mean. And here, if you look at Article 24, the archives and documents, and the article does not specify archives and documents. So it's basically to bring about that component. And of course, if we talk about the Vienna Convention, indeed, we would imagine an operation, cyber operation against a Ministry of Foreign Affairs, for example, against the archives and documents. But here again, if we say that international law does not apply, then even ministries of foreign affairs, which otherwise assume a high level of security and inviolability, would be open for attacks. If that does not answer your question, let me know once more. But
No, thank you so much. Thank you.
Perfect. Yes, thank you for your question. So back to IHL again. We will actually apply that same logic which we stated earlier, examine the specific content of the individual rules to determine whether they apply. Yeah. And of course, the other side would have to come up with questions like that. How perhaps Kenzie's question could be taken as one like that. How do you mean that the Vienna Convention applies here? So you try to say that Vienna Convention was not meant to regulate cyber operations, and that should be regulated by something else. There is no treaty, there is no political will by states, and then you could actually start from that point and argue against the application of Vienna Conventions or any other convention for that matter. The main or the consensus here would be that IHL applies to cyber operations as it does to conventional operations. So we have three outcomes here. One, that belligerents or fighters would have to comply with IHL when they conduct cyber operations. That's first of all, and that those actors, by actors I mean belligerents, as well as the states which have to ensure respect of IHL, would be responsible for violations of IHL, even in the cyber domain. And in that sense, IHL can protect the victims of armed conflict. So this is basically the summary. At least that's my position, or the position that I relate to most, that IHL applies to cyber operations. This is more on the general side. You might need to understand more about that. If you're gonna argue a moot case that has to do with cybersecurity, you might not need to delve into these wider issues, but really delve into one, make selections, make choices that suits your side of the argument, and then if you're asked by the judge, then you can go back and bring these examples to the battle. Okay, let's start by the famous nuclear power advisory opinion by the ICJ. And if you read with me, I think you would be quickly convinced that cyber operations, or any operations of the future, may be drone operations or lethal autonomous weapon systems, space operations, all these new technologies, they would be covered by IHL based on that exact paragraph 86. So maybe we read on it. If you look at the first part, the court shares that few, indeed, nuclear weapons, and here, of course, it talks about nuclear weapons, not cyber operations, but we will make the deduction, were invented after most of the principles and rules of humanitarian law applicable in armed conflict. So basically, this states that the law was invented first, or was written down first, and then nuclear weapons were created. And then, however, if you look, it cannot be concluded from this that the established principles and rules of humanitarian law applicable in conflict did not apply to nuclear weapons. So basically, the fact that the law was created before the advent of a new weapon doesn't really mean that the law does not apply to that weapon. It applies. That's the position of the court. And if we look at the midsection, we would see that such conclusion will be incompatible with the intrinsically humanitarian character of the legal principles in question, which permeates the entire law of armed conflict and applies to all forms of warfare and to all kinds of weapons. So basically, you can rely on this decision, or you can bring it forward if a judge asks you, or if you would like to write something about cyber operations. That could be one of the starting points, that the position of the ICJ in application of international humanitarian law, that law applies to new weapons and to all means and methods of warfare, however they are. Okay, let's also look at the position of the ICRC, which I think is quite predictable, so to say. And the ICRC states basically that there's no question that IHL imposes limit on cyber operations during armed conflict, just as on any weapon, means, and method of warfare used by a belligerent in a conflict, whether new or old. So that's, if you want to check the position of the ICRC, basically that's it. And you can, of course, always rely on the position of the ICRC because it's seen as the protective of IHL and the one that really develops it and sustains it and disseminates it. So that's quite an authoritative kind of text to rely on. Also, we look at how the ICC looks at cyber crimes. This is basically recent. It's basically the position of the OTP, or the ICC prosecutor Karim Khan, which basically did not really deny the fact that the Rome Statute would apply to cyber operations, on the fact that they could constitute war crimes or crimes against humanity, crimes of aggression, and genocide. So if we go more into the ICC or the international criminal law kind of international law, we figure out that in application of IHL, the ICC would not rule out cyber operations because they are not mentioned. So that's that. And we find some statements from Karim Khan in some of interviews or articles that he is saying that either that the Rome Statute applies, or either that they are actually investigating cyber crimes, or that they are working on policy papers, which they often do for specific topics. We also see that other groups, such as researchers of UC Berkeley, who looked at existing cases, tried to, I believe it was a communication that was sent to the ICC to point out that there are cyber operations by bringing relevant evidence to the attention of the court. And that's also might be used as indication or evidence that ICL and IHL both apply to cyber operations by practice. Of course, once we tackle these larger questions, we would then need to go more technical in our argumentation, our position about IHL and cyber operations. And of course, the first question, which we delved into last time over and over again, was armed conflict. Does an armed conflict exist? And for cyber operations, that is a very relevant question that you might need to ask every time when there is a cyber operation. So why do you ask that question? Because IHL principles and rules apply only to situations of armed conflict. So we always have to ask whether there is an armed conflict, and that is the subject matter of IHL. And as we touched upon nicely last time, we talked about the assessment of armed conflicts, and that it is a legal assessment that doesn't depend on legal or political declarations or declarations of war or recognition by states. So it's 1 + 1 = 2, basically. It's an objective assessment. And the objective criteria that we found were basically those that were found in Common Article 2 and Common Article 3, and as well as the the Tadic case, which basically point out that there are two types of armed conflicts, IAC and NIAC, and if you have a situation of NIAC and IAC, IHL would then apply. So that would be the chase then, to prove that there is an armed conflict in which or through which a cyber operation was conducted. That also we talked about, that determining whether IHL rules apply, we would have to determine whether there is an armed conflict, and that doesn't really have to do with the question of whether this armed conflict was prohibited, whether the use of force or the attack was illegal under the UN Charter. We also discussed or concluded that IHL differentiates between those two types, armed conflicts, IAC and NIAC, and every time we would have to have an assessment per se, and different criteria, of course, apply to each one of them. If we look at IAC, of course, it's an armed conflict that applies between two states. Could be a declaration of war, could be occupation, could be just a normal attack from one state to the other or between more states. It has to involve states. And the criteria are, of course, found in Common Article 2. And if we look at NIAC, that's a bit of a reminder, then we are talking about an attack that took place between a state and an armed group, or between an organized armed group and the others. So that would, and of course, an excellent question here might be, do I actually have to do this again when I'm trying to tackle a question which relates to the case? Do I need to delve into conflict classification when I'm dealing with a cyber operation kind of question? The question would be, or the answer would be that it depends. So if, okay, maybe I will, maybe the answer would actually appear on the slide. So I'm not gonna get ahead of myself. So let's go one by one. So we talk about cyber operations in international armed conflicts. And we have cyber operations that actually took place while there is an international conflict that is taking place. So there is an international armed conflict already happening. We already classified it as one. And then within it, an operation took place from a state against the other. And as I said, the operation was basically in conjunction with another military operation. So, for example, one state decided to attack a military base in state B, and state A again also thought, okay, before we move in by our troops, we are also gonna hack the system or the internet in that building to disrupt their operations and their communications before we get in. And you see that this is a cyber operation that was done in conjunction or in parallel to a classic or conventional military or kinetic military operation. In this case, it's more certain that IHL would apply. So this is the most certain time where IHL actually applies. And you can read more on that on the commentary on the Third Geneva Convention, paragraph 287. Okay, and then we have another operation that takes place outside an armed conflict. So we have a cyber attack or a cyber operation in the manners that we discussed earlier in the previous slides. And that attack came out of nowhere. So there's nothing going on. State A, State B are sort of a neutral state. But then State A or entities from State A affiliated with the state decided to attack State B via a cyber operation alone. So the question would be then whether IHL applies, and before that, whether this would qualify on its own as an international armed conflict. And then we see here that that the law is unsettled, whether a cyber operation on its own can actually bring an armed conflict to existence. So here we see more room of debating between positions, and the law is not really clear. So I think state practice would really settle this over time. But as of now, this matter is freely debatable. by experts. And we see that that there are also two types here, cyber operations having similar effects to classic kinetic operations. So the first type is that we are about a cyber operation that didn't take place in an armed conflict, in an existing armed conflict, and that cyber operation actually brought a humongous or a massive destruction or damage to the civilian population and objects that we would equate to a normal military or conventional attack. And in this case, in this particular case, most of the experts and the states, all as well as the ICRC, stated that in that case, that attack could bring on in its own a situation of armed conflict. And then we have a cyber operation that disrupt military or civilian infrastructure, but without physically destroying or damaging it, or at least bringing a similar destruction as would be with a normal or conventional armed attack. Here we see that both the ICRC and states would have less interest, so nobody would, perhaps much less voices would say that such an attack can on its own qualify the situation as an armed conflict. And my position on that would be that more state practice is needed to come to a conclusion, and that, of course, there is much room for debating and creative argumentation. I say here, if and under what conditions states treat such cyber operations as a resort to armed force between two states. So that would be really the question, is to look at states' practice and their sense of obligation, whether a specific attack would actually would actually, from their view, constitute a cyber operation that amount to a resort to armed conflict between two states. Okay, now we go to NAC. We also have the same large distinction between a cyber operation that takes place in an existing or ongoing non-international armed conflict, and we have the other one, which would be a cyber operation outside an existing NAC. The one that is takes place within the ongoing NAC would be, of course, the same operation that takes place in conjunction with a conventional military operation. But here, of course, the actors are different. We would talk about state and non-state armed groups, or these groups among each other. In that case, it's the consensus that IHL applies to these operations. And same again, we look at cyber operation outside an existing NAC. And perhaps this is, so again, we talk about a cyber operation that takes place between a state or non-state armed group, but that cyber operation basically took place without the existence of an ongoing armed conflict. And the question I raised earlier about whether we need to qualify it, of course, would be based case-on-case basis, whether the facts that you're dealing with relate to one of those, and then if you feel that you really need to assess the situation, then it might be necessary at least to have to make a position on whether IHL applies, whether this cyber operation took place in an IAC or NIAC or none at all, and whether IHL applies. So it might be beneficial for state A to argue that IHL doesn't apply. In that sense, dealing with that question might be optimal, but state B could anticipate that kind of argument and then argue against it. So it really depends, but I believe you might need to consider it in all cases, that type of question, whether the cyber operation I am analyzing at the moment took place within the context of an ongoing armed conflict. So here we see that for NIACs, then we are having another puzzle, which would be that whether the cyber operation itself amount to violence that is intense, as we classified last time, with the indicative elements that could protractedness, the duration, the amount of operations, all that kind of stuff, would lead us to assess whether an attack is intense per se, and that the armed group or the armed group that launched the cyber attacks would have to be an organized one. In that sense, we are having more difficulties again with NIAX compared to IX. And if you look at the literature, you would see that if you look at the current state of technology from the point of view of the existing literature, we find that this situation is almost impossible, that a group in a like would have the level of intensity and level of organization necessary to launch a cyber operation that would qualify per se as an armed conflict. But never say never. Okay. Yeah, and of course, as we did last time, and as you would usually do with armed conflict classification, there are situations that would not qualify as armed conflict, attacks that would qualify less. So those could be other forms of cyber crimes that normal or domestic law would apply to them, human rights law would apply to them, and the UN Charter, but not the framework of IHL. Okay, so we get again to the same point, that the essential question is not whether IHL as a regime of international law applies, but whether and how every individual rule and principle apply in cyberspace. So this is the exercise that we did with the Vienna Convention. We can re-examine here also by looking at the Geneva Conventions. And for example, we would have rules that would apply to detaining powers or to POWs, where the POWs would have to be given, and I'm leaving some materials here for you, would have to be given sufficient water and soap, cleaning, they have to be catered for, they have to eat, all that kind of rules. And of course, these kind of rules, it's hardly relevant to cyberspace. So these rules would be ruled out per se, because the text itself sort of rules out the possibility that they would apply to cyberspace. But certain principles and rules clearly apply. Of course, the principle of distinction, precautions, and proportionality, as we will come to discuss in the remaining slides. And there are, of course, other rules that, bit of that and bit of that, you would have to extend them by force of argumentation to say that this rule applies or not. Such as the duty to enable prisoners of war to send capture cards. So capture cards are, once a belligerent is captured, they have the right to send a card to their family or to their commanders to tell them that they are captured and tell them about the whereabouts. And that rule was basically, was before the digital age. And we don't know whether this applies to emails or to other forms of digital space. But here, of course, the argument can be made that it indeed applies, or why not doesn't it apply to emails and electronic means? Okay, if you remember that slide, which one of you shared on LinkedIn, I like the photo myself, so I was happy to see it also featured. So again, we will come again to the equilibrium of IHL, and that's basically what it comes down to. That cyber operations are basically governed by the general balance between military necessity and humanity. And of course, as I said last time, and reiterate again today, that you cannot apply those two principles directly to a specific operation, but you can bring them or mention them perhaps when asked, to say that IHL would apply because it always requires a balance between military necessity and humanity, but there is no specific norm. There is no normative standpoint that you can bring forward to say the judge should rule this way or that way. But the applicability also of the equilibrium of IHL would hinge upon the Martin's clause, which I will share with you in the next slide. but we'll come to that and I will talk more about it. So first we have to be about, so this would be the process once you qualify, would have to be about a cyber operation that amount to an attack within the meaning of IHL. And I'm wary here because I might touch too closely to what you need to do with your case. So I'm not really going to define what would constitute an attack because I know that this is a question, but they are basically, as you come to find, they are acts of violence against the adversary, whether in offense or defense. You might find commentary, you might find specific rules that talk about that. So go ahead and do your research. But in all cases, to talk about cyber attacks, we of course have to fit cyber attacks or any other attacks within the meaning of attacks per IHL. And once we have established that these attacks constitute attacks within the meaning of IHL, then we have, and of course, the general idea of classification as well as military necessity versus humanity would have the three cardinal principles of distinction, proportionality, and precaution. And of course, we would define those and try to use them to define or to engage with a specific operation. And there's always a space for debating here. For distinction, for example, one side might argue that this was dual use, both by military and by civilians, and it was somehow legitimate to be an objective of an attack. The other one could say that this attack specifically intended to attack civilians, and then it goes this way. Same with proportionality. One side may say that these attacks are excessive in relation to the military, or the collateral damage is excessive in proportion to the military objective required at the time. And the other would say that it's not excessive. So it goes like that. You apply those three principles. You don't have to, like if you have 10 operations that you need to analyze, you don't have to analyze the three principles every time. Sometimes one of these principles would be actually the crux of the matter. So for your case, you have to make that assessment yourself, whether you need to apply the three principles, whether it's relevant to only apply one of the three. It really, it's up to you. And of course, you have to take time into account when you make these arguments in your oral pleadings, but maybe in your memorials, you can be elaborate if you have the space and the amount of words. And then we see here that rules that apply to especially protected persons. So indeed, when especially protected persons or objects were harmed in that attack, we can then provoke more of these articles. Nowadays, I feel that these rules, although there are many and they are important, and the ICRC talked about them so many times in light of the situation in Gaza, I feel too disappointed about these rules, but only time will tell. And my answer to that always, at least to myself, the painkillers that I take for that kind of question is that international law would not be effective if we don't do something about it. So many of us could say that international law is not effective. People are dying, this and this is happening. But at the end of the day, it's up to us and up to how good we do research and how good we plead and how well we read on these subjects that would define IHL and also international law in the future. So it's a bit of a positive note for your case as well. So to get ahead on that, but these rules that apply specifically to protected persons might be relevant also to your case. This is all what I'm going to say about it. So this is the Martin clause. And actually, if it comes to, of course, in a moot court also, you don't know exactly how the case would develop. So you might be taken by the judges or the opposing counsels to a corner where you would have to bring everything possible to argue that IHL applies. And usually experts do rely on the Martin's clause all the time. I don't like it per se because it doesn't reflect positive international law. And I'm a positive school kind of person, which means that unless the law is specified and written down and consented by states and relevant subjects of international law, then it's not law. So there's a difference between what is law, which we would find in Article 38 of the Statute of the ICJ, the custom, the treaties, and so forth. And we would have other things that would qualify as ethics and philosophy. And for me, the Martens Clause stands really in between. It could have some damaging effects, but generally it is usually relied upon by lawyers as well as by academics to say that ICL applies, because basically that clause states that anything that is not governed by these Geneva Conventions or ICL in general would still have to be ruled or regulated by the laws of humanity and the dictates of public conscience. And there's no really definition to these principles, but basically it always brings the component of humanity or the principle of humanity to the conduct of war, which I think is a fair assumption when it comes to ICL. Okay, so I think all the practical aspects are now done. So if you're strictly looking at this, we're about to finish, Abdurrahman, right? So it's about an hour. So I left some slides here, perhaps for you to look at, and for those who would like to carry on and do research into these aspects, perhaps as part of their master thesis, bachelor thesis, or any other project. So these are other aspects that are more theoretical, less relevant to day-to-day operations or, to your mood case even. So we have the issue of attribution, which I believe every person who works in that information technology domain would know of. The issue of attribution, whether cyber operation in the sense of ICL or cyber warfare would be attributed to someone. Of course, anyone can deny that these operations were not carried out by them. It's also difficult to identify who carried out these attacks. And in the end, the standard of proof in domains like ICL, ICC in particular, is very high. You have to prove beyond reasonable doubt that this person actually carried out these cyber attacks, which seems a bit fuzzy at the moment. The gravity is also a bit of a question. It's really difficult to assess the size of damage that one cyber attack did. It could have insane effects that we are not aware of, but still, as from a technical point of view for courts, still this is a bit of a difficult kind of question, but also an opportunity for researchers to look at and try to find solutions. One of the solutions that I think could be relevant, which would be the immediate focus of the International Criminal Court on incidents that would include both conventional operations, but also cyber operations, as we talked earlier. If the ICC would give more attention to that, the problem of attribution at least would be covered. I thought I have more, but that's good. So in summary, the summary is really quite general, but I intended it to be so that you go out with the main key point, which would be that ICL applies to cyber operations occurring during and to lesser extent to those operations triggering by themselves an armed conflict. So cyber operations can happen during an armed conflict, and they can trigger an armed conflict, may it be an international one or non-international one. And we saw the levels of certainty of the law depending on each situation. And which is reflected in the second point, determining the beginning of an armed conflict remains tricky in situations where cyber attacks are employed alone, short of any kinetic or physical use of force. Of course, once the applicability of ICL is triggered, the question becomes of one that has to do with the adaptability of these rules. How far can we adapt the relevant rules or the rules that we think that can apply to the conduct of hostilities in question, which would entail cyber operations. I think that's it. I'm glad that this time we were almost exactly in time, and I'm glad also we took some questions. So it sounds like a fair distribution of time, and I'm still looking forward to more questions if there's any.
Thank you very much, Walid. The last hour was brief but rich with information. Walid has taken us in a journey from practical examples on cybersecurity attacks, those in the Russian-Ukrainian war and the Israeli-Palestinian war as well, or aggression rather. And then we spend the rest of the time discussing the applicability of IHL on cyber attacks. Walid has made such an interesting distinction between potential applicability on IX and NIAX, figuring out that some difficulties in the classification, the beginning of the attacks, the intensity of the attacks as well can be obstacles against the application of IHL, as well as general doubts as whether it should apply altogether or not, given that the Geneva Conventions were all concluded before the very existence of cyber attacks. But I think it's just a matter of time before, just as you said in the middle, before we figure out ways to have it applied, because think of a more advanced world where people can trigger all the forms of physical suffering and even psychological suffering, but physical suffering where you're just at home. You can just bring out all the infrastructure. Imagine, for example, breaking down a water filtering station, causing the pollution and poisoning, mass pollution and mass poisoning. If that's not an attack worth triggering IHL, I don't know what is. And we concluded with some open questions. I think that's the place where the participants with us today are lying at the moment. So thank you again, Walid, for the very rich, interesting topic. It was, as promised, I think very helpful to us all, either as just assisting people or participants. For the time being, does anyone have a question to Dr. Walid in relation to the presentation? Well, I guess it was, everything was clear enough.
I also see a couple of questions, Dr. Abdurrahman, with in the text.
Missed that. There is one from Tabang, excuse my pronunciation. Given the challenges of the attribution and the dual use nature of many cyber systems, how can an IHL effectively enforce the principles of distinction and proportionality in cyber warfare? I think that's the core of the question. How distinction and proportionality can be applied under IHL given the dual cyberspace and tools. Additionally, what steps can be taken to adapt existing legal frameworks to keep pace with the rapid advancements in cyber technologies? Let's start with the first question then. How proportionality and distinction can be applied for cyber attacks?
I think it's an excellent question indeed. I think it has to do with the slide that I brought back to the screen. And first, let me analyze the question a bit, because you ask how can international humanitarian law effectively enforce? And the word effectively here has to be defined a little further. So for us to have a normative view on how this could happen, we have to adopt a specific standpoint. So that standpoint could be legal, and that's what I did today. And I would argue for how the rules can be applied, and I provided the methodology for that, to look at each particular rule and see whether it can be extended to a specific fact. So this is how it could legally effectively applied. but effectively could also mean economically effectively, could also mean peace, which is a larger kind of question. Could be anything that you put behind the word or after the word effectively. But I also see the word enforce, and enforce, I would assume, has to do with ICC. And I think I also touched upon that. And I think if I answer in the words of Karim Khan, that would be to have more focus on these kind of operations by first asking the team of Karim Khan to look or to create or to draft a policy paper on the topic, but also to effectively address these kind of questions and try to investigate cyber crimes. And it's also funny because the ICC itself was the subject of attack allegedly by Russia recently, and the attack brought down the court out of operation for I believe 2 weeks in a row, in which the court was paralyzed and unable to do the function it was meant to do. So this is how far cyber operations are reaching. They reach the court itself. So in terms of enforcement, I think what the ICC prosecutor is doing is relevant, but I believe again it has to do with states. So it's us who can bring that to enforcement. We have to talk about it. We have to make moot cases about it. We have to bring it in our literature or writing, in our lectures. Just talk about it more and more, but not any talk. We have to make informed argumentation. And then, of course, it's also up to organizations, human rights organizations or IHL organizations, the ICRC, to talk about this further and try to bring the states to come together and come to a decision. And I think that would be the optimal way to effectively enforce the principles of distinction, proportionality in cyber warfare. I hope this answers your question, because it's a bit of a general question, but it is a relevant one, and it could be a start for you to look into it further and do more research onto it. I would be personally interested to read on that. Additionally, what steps can be taken to adapt existing legal frameworks?
I think you've answered already.
So that's basically another way. Thanks, Tabank, for paraphrasing the same question so that we can understand. I hear that you nod that it's went well. I actually would like to take opportunity to clarify something before we move on with the next question, because the moot case that you're dealing with also raises questions that has to do with psychological warfare. And this has not been the subject of this presentation. So psychological warfare, which also has to do with information. So you see the parallels here, that information would come again, but in a different way. And psychological warfare would have to do with misinformation, really. And regardless of whether it was cyber, it was media, it was by physical papers like these that you distributed, it would come in many ways. But the common denominator would be information. And this was not covered today. So this have actually more rules that talk about it, and I just want to clarify that this was not tackled today.
Okay, perfect. But everything else was tackled, so
good.
Thank you. Well, I can't see any more questions at the moment.
I see a question about the facts, but I think that was for you. But
I think that's already tackled. I think questions. Reaching out to the case author Walid in that case for us in relation to the case facts, that was dealt with in the phase of the clarifications. The purpose of these sessions is to perhaps shed some more light on law, on not rather than the facts. You're of course most welcome to pose any questions in relation to the ideas raised by Walid today, as long as it's within the boundaries of law, legal questions. I don't want to be the cheater here, but you can always disguise the facts within an abstract law question. If you have
to be done,
if you have the time, you can always do that. And
yeah, and we already answered some of these questions
indeed,
in writing. So I believe you might, if you don't have further questions about the facts now, it's understandable because you've already asked some of which I hope you've read the document, because it should be helpful to all teams. And for cyber attacks, I think it was covered today. So it looks good to me, Abdurrahman.
Yeah, all is perfect. I think then this concludes today's session. Thank you again, Walid.
Of course.
I personally really enjoyed that. Thank you for joining us for 2 consecutive sessions. We're looking forward to have you in Egypt, inshallah, at the time of the competition. For them to ask you the question they need to ask you after the competition is concluded.
Yeah, absolutely. And maybe if I'm lucky, I could be there at the time, so to grill the students with some questions as a judge. So we'll see how it goes from now. But I wish everyone good luck, organizers.
Thank you.
Yeah, as well as the students. Good day. Bye-bye.
Goodbye, everyone.